Hey, Mr. Charles, come on up.
Right there. And Judge, with me is one of the assistants, Jennifer Rhodes, and our summer intern, Emmy Hanna, who is an undergrad at UVA.
Excellent. Quite the summer following around Mr. App.
You want to correct it? What are you really good?
No, I liked it. It's you were already shoving me out the door.
I think my daughter got to meet you and was very impressed.
I don't know about the oppressed part, but I did get to meet her.
She was very impressed. She is part of the Schwal, I don't know what you call it.
Schwal Army.
Schwal Army. Schwal Cabal. I don't know. Just over the president, take it all. Get that whole trial stuff. All the things. It's not called.
What is it?
Yeah, that whole.
This week.
I'm not sure.
Okay.
Alright. Yesterday I was
Good morning, Ms. Tuos. Are you able to hear us?
I'm sorry. Yes, I am.
Great. We're going to get started in just a sec. So, Mr. Abadi, I'm ready when you are. You good to go? Do you need any family members plugging in, or you've got what you need on that front?
If they're not on the Zoom,
You've let them know. Okay. Mr. App, do you need a couple more moments with Mr. Charles?
That would be lovely if we could just have 5 minutes, Your Honor. I apologize.
Okay.
That's their both, like, on the premises.
Okay.
So, let's see.
It's particularly important that Ms. Johnson is here?
Yes.
Okay.
She sounds like she's ahead of Ms. Charles.
Okay. What's happening with Ms. Charles?
I don't know.
Okay.
I've sent a new counteroffer that I'm not.
Okay. And it's Ms. Williams's case, I believe. Okay.
I'm assuming this plea is about to be ready to go.
Yes, Mr. App just needs a couple moments to talk with his client.
Awesome. Taking the office. No, she's still like in the wind.
Where'd he go?
Yeah, great.
So.
Nice.
But it is what it is.
Deputy Gordon, Ms. Johnson is on her way.
Wait, where's she at?
Okay, but are we good to, there's like 400 people back there. That's gonna be all right? Okay. Okay. Once you get, I've got the final disposition right here, so I can do that once you have her. Is this the? It's not this case. What did she shot Chance Jones?
It was
Allegedly.
fly over a van in the parking lot and the bullet was intended.
Oh, and she shot up into the breezeway and hit the kid in the leg. Yeah, okay. It wasn't her gun.
Not her man either.
A series of unfortunate decisions.
Truly.
We still don't have Kayla Brown. She's still out there. Yeah, that's,
Does she get a sentence increase when she comes in?
oh yeah. And I told Ansel, like, you have a badge, there's a warrant.
Yeah.
Well, I'm gonna go through the sheriff here, who will call the sheriff there. Mm-hmm. Please. I figured Wooten would want to go do it. Actually, the posse comitatus, I'll tell you who wants to do it, would be the victims.
Oh my God.
If they knew it would be a citizen's arrest. Yikes.
If you have understand, we're rather it's sealed for society.
Your record can be sealed.
Can maybe. The parents of teams first defend Gables. If you mess up over probation, let's say you get 10 years probation on it. You steal it. You use your first offense. No, let's say you get 10 years probation, you steal a car, you don't use your first offense. 9 years in probation, you get arrested. You get a DUI, 9 years old. Well, Johnny brings you back from stealing a car and says you violated the probation because you got arrested. I'm throwing the book at you. So I'm gonna give you 1 year in prison, which is the max. So only 1 year left on probation. Yeah, you understand that, right? Now let's say you steal a car. And you get a first offender. You get the same thing on probation, 9 years in, You can re-sentence you, put the felony on your record, and give you 10 years in prison. Because that was the maximum you could have done. Re-sentence completely. The judge. So it's a character state. He will lead it once, he will lead it. And they allow you to get your records. Now there's another statute that correlates with center thing. Which says if you do less than.
I think he
was. I want to do that first and better steps. And for years. There's yet another section.
Good morning, Ms. Johnson. Thank you for being here. Appreciate you being on time.
Sorry, Your Honor, I appreciate the time to talk to Mr. Charles, and we are ready to proceed.
Excellent. Then let me click on one thing and we will get on the record. All right, Ms. Toulos, we're going to get on the record, please. This is case 23 SC 187925, State versus Charles. Mr. Charles is here. He is represented by Mr. App, who is also here. The state is represented by Mr. Abadi. And it's my understanding that this is a plea. Is that correct, Mr. App?
It is, it's a negotiated plea, Your Honor.
Okay. Mr. Charles, in just a moment, Mr. Abadi is going to put you under oath. Mr. App, are you, because our court reporter is virtual, is it all right if the two of you come up to the podium?
Of course.
And Mr. Abadi, if you come to the witness stand, that way she'll be able to see you as well as hear you. There we go. Mr. Charles, in just a moment, Mr. Abadi is going to put you under oath. Once you're under oath, you need to answer all his questions truthfully and completely. The questions are going to be all about things you and Mr. Apt have already discussed, your rights as a criminal defendant, some things about the case. If at any point during the conversation the four of us are having, you have questions, you need to let me know. Will you do that?
Yes.
Okay, you're gonna need to speak up a little bit so the court reporter can hear you. And if at any point you want to speak privately with Mr. App, just let me know. You guys can step outside. We'll pause until you've had a chance to discuss with Mr. App whatever it was you wanted to discuss. Will you let me know if you need that?
Yes.
Okay, that was better volume. All right, Mr. Abadi, when you're ready.
Raise your right hand. Do you solemnly swear or affirm that the testimony you have to give in the matters pending before this court will be the truth, the whole truth, and the truth?
Yes, I do.
Please put your hand up. If you could, please state your true, correct, and legal name for the record.
My name is Rognald Charles.
And Mr. Charles, are you at this time taking under the influence of any alcohol, drug, or medicine?
No, I'm not.
Regarding medication that you take on a daily, regular basis, that you haven't been able to take today that affect your ability to enter into this guilty plea?
No,
How old are you, sir? How far did you go to school?
I'm 39 years old and I finished some college.
Okay. And so are you able to read, write, and understand English language?
Yes, I am.
Okay. And do you understand in indictment number 23 SC 187925, you're charged for 2 counts, count 1 murder, count 2 felony murder?
Yes,
And do you understand through negotiations with your defense counsel, both of those counts will be reduced to voluntary manslaughter under 16-5-2?
yes,
Okay. And do you understand you have the right to plead either guilty or not guilty to the charges, plead not guilty or remain silent when they receive the jury trial?
yes,
Have you had enough time to speak to your attorney, Mr. App, about the facts and circumstances of the case?
yes.
Do you have any questions at this time in regards to any of the facts, potential defenses for your counsel?
No,
And are you satisfied with the service provided to you by your counsel?
yes,
With that, you waive formal reading of the indictment?
We do,
You waive any non-defects in the indictment in respect
we
to
do,
your client's name?
we do, sorry.
And Mr. Charles, was your attorney advised you of the minimum and maximum sentence of charge you're pleading guilty to?
yes,
That he advised you that the voluntary manslaughter, how long? 1 year and a half? 1 year?
yes,
Yeah, no question about that?
no,
And do you understand that this is a negotiated plea of guilty, meaning that the state and your counsel can make the same recommendation to the court, 20 years probated sentence. But the court does not have to follow that recommendation and sentence you as he sees fit.
Yes.
Do you understand that this plea may be used to enhance sentencing other convictions in this jurisdiction as well as in other jurisdictions within the federal courts?
Yes.
And do you understand that you are not a United States citizen? A guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed to you unable to come forward an attorney for the trial of your case,
Yes.
the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel production of evidence, the right to the charge of guilt should be proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges at the trial. You understand that by taking a plea here today, you're giving up or waiving all of those rights, sir.
Yes.
Has anyone, Mr. Charles, forced, threatened, or promised or anything to get you to enter a guilty plea here this morning?
No.
If your decision to waive these rights to enter a guilty plea, if you're in fact in such a state of plea, guilty to voluntary manslaughter.
Yes.
And as it relates to count 1 and count 2, count 1 murder, count 2 felony murder, both being reduced to voluntary manslaughter under 16-5-2. How you plead to these charges in at number 23 SC 187925.
Guilty.
And is this guilty plea served freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you have a limited right to appeal this guilty plea conviction?
Yes.
Do you also understand that Georgia law gives you 30 days from today to file a discretionary appeal off the direct appeal? Previously, there was a direct appeal from this guilty plea. And you also have until the end of the term of this court, or 30 days, whichever is longer, to file a petition for a motion to withdraw this guilty plea.
Yes.
Okay, do you have any questions about the time frame or the time in which those must be filed, sir?
No.
Do you understand that you have only 4 years from today for a felony charge to file the habeas corpus petition challenging this guilty plea?
Yes.
Okay. Or do you have any questions about the process of what a habeas corpus petition is for your counsel or the court?
No.
I think you're asking to figure this out, am I right on that?
We are not asking for first offense. He's not eligible.
Right. Your Honor, had this case proceeded to trial, the state would have shown during the trial of the case on May 29th, 2017, at approximately 11:36 p.m. The defendant, Charles, was at the A2C Budget Hotel where he was staying. That hotel is located at 4265 Shirley Drive in Atlanta, Georgia, here in Fulton County. He was staying in room 339, which several witnesses from the hotel who were also staying there confirmed that he was staying there. He was known with the hotel by his nickname, which was Slim. What the witnesses who were interviewed by the detectives who showed up shortly after 11:30 when shots were heard and fired, and Mr. Jeremy Braswell, the victim in this case, was located on the 3rd floor of the hotel, shot twice in the chest. Through their investigation, they were able to get a very grainy surveillance video, not being able to make out anybody's identification, just that there was 2 people who both looked like males. But in speaking with the residents of the hotel, management of the hotel, as well as security for the hotel, what they were able to uncover or determine was that earlier in the day, the victim in this case, Mr. Braswell, had robbed Mr. Charles at gunpoint, and taking approximately $90 and some other items from his person. And again, this was at at gunpoint, and from all the witnesses, recitation of what they knew had occurred, Charles was pretty caught off guard by the robbery, the armed robbery, and left pretty fearful after the robbery. The victim, when he robbed Mr. Charles earlier in the day at this hotel, he was not a resident of the hotel, like the defendant in this case. So later that evening, around 11:30, they happened to cross paths again, coming up and down the stairs. And as Mr. Charles was coming up and Mr. Braswell was crossing over on the third floor, they saw each other. And what the evidence would show was that when the defendant saw Mr. Braswell in the hallway reaching for what he believed to be a gun based on his earlier experience of being armed robbed at gunpoint earlier in the day, at that point, Mr. Charles, who had armed himself since the armed robbery due to fear of what had occurred earlier in the day, pulled a firearm and shot Mr. Braswell twice. Mr. Braswell went running one way, the defendant's case went down the stairs and left the hotel and resident area. We were able to speak to multiple witnesses who heard the shots, but no one was able to identify the two parties who were involved in the actual shooting. Everyone obviously was able to identify the victim because he remained deceased. But phone records put Mr. Charles at the scene, and through a friend of Mr. Charles, the detective was able to determine that Mr. Charles shot the victim in self-defense based on his fear from being armed robbed and his fear of staying on scene is why he fled. Based upon all of that, Your Honor, the state would have proved beyond reasonable doubt. So what I can say is, unfortunately, I don't want to speak ill of anyone who can speak for themselves, but in the investigation, what the detectives uncovered was that Mr. Braswell was known in the neighborhood to armed robber at one point pretty regularly. This was his MO, the thing that he had been doing. And he, from speaking with Mr. Alexander Woods, had indicated to him that he knew this possibly lead to his demise was quickly distracted.
Who was Alexander Woods?
He was another resident of the hotel, was familiar with both.
Okay, was able to give some context to who was who in that community.
From my review, Mr. Charles had one felony conviction that he pled first offender to back in September of 2022. It was a simple possession of cocaine and a misdemeanor obstruction of 17 SC 151574. In my review, I believe that he's been discharged and he was able to appropriately complete all conditions of probation.
Okay, thank you.
And for the record, I did notify the father of the victim, Mr. Braswell. He indicated he would attempt to try to
This just in.
So I'll send the Zoom link to our victim advocate, and I believe the mom who is in another location would like to make a short statement.
Sure.
Prepare the court. We might speak with the father. This is not a resolution that she is pleased with or happy with, but in totality of the circumstances, based on everything, this was the fair recommendation state.
Okay. What I think I'll do is I'll pivot to Mr. Apt. We'll start the defense presentation, and then as soon as a Braswell family member is on, we'll pause that so we can hear from whomever, and then we'll wrap up with whatever else Mr. Apt and Mr. Charles might have. So with that, Mr. Apt.
Your Honor, Mr. Abate sort of stole most of my thunder and did an excellent job of not only describing what happened, but also some of the background about Mr. Charles. He's 39, Judge. He's got some college. He's a full-time truck driver up in the state of New York. He's flown down here with permission of the court, which we appreciate, and appeared either virtually or in person at every court appearance. He has taken this case very seriously for many, many years that it's been pending. I don't have any qualms about denigrating the alleged victim in this case. He was known to rob people at gunpoint frequently and did so to Mr. Charles earlier in the day. As a result of that incident, Mr. Charles, who wasn't really familiar with guns or used guns, felt the need to arm himself and borrowed a firearm from a friend. And unfortunately ran into Mr. Braswell again that evening. He's pleading guilty. We're not even asking for an Alford plea. I think had the case gone to trial, there would have been a pretty clear self-defense argument. But it's difficult when the state makes a probation offer on murder for us to say no. And we are, as a result, humbly, respectfully asking the court to accept that negotiated plea. He understands that he played some role in this and is pleading guilty to it freely, knowingly, willingly, voluntarily. And that's really all I have, Your Honor. You've heard the facts and circumstances. And so we are humble always before this honorable court and ask you to accept the negotiated recommendation.
Okay. Mr. Charles, you have a right to be heard. If there's anything you want to add, you don't have to add anything at all. But if there's anything you want to share with me, I'm happy to listen to it.
I'd like to apologize to the family of Mr. Braswell for my role in the whole situation. And that's really it.
Okay. I'll be sure to pass that on in just a second, should someone join the Zoom call. So you are in New York now. That's home base for you. This sentence is going to be a little complicated at first because it's a Georgia sentence.
Yes.
And you need to stay in Georgia until your probation is transferred to New York. You can apply. Hopefully, I'm not telling you something new. You've discussed, at least basically with Mr. Apt, that you're going to need to be in Georgia for a little bit.
Correct.
Okay. We don't have probation here, but we will reach out to probation, and you can help streamline this. There's a payment that has to be made. They need to get some paperwork about your case. Mr. Apt can help you with that. Until, I'm assuming New York is where you want to go back to reside. Is that correct?
Correct.
Until New York accepts supervision of your case, then you need to be in Georgia. You actually can't leave Georgia. So I appreciate that you are a truck driver, but your trucking routes, if you're going to be working, probably need to be in Georgia. We'll talk about maybe some flexibility of if you can document where you're going, you could drive further than that. But probation gets a little nervous about someone, especially with what these allegations are, if you aren't real easy to find. Tell me what your plan is in terms of where you'd be staying, hopefully not at the A2C hotel.
Absolutely not. I won't be staying there. But is there a timeline of how long it takes for the?
So it depends by state. I don't know how quick New York is. Some states drag their feet. That's the wrong way. They take longer. Others, it's quicker. Your charges may cause New York to think a little harder about it because it's not a shoplifting case that they're being asked to supervise, but they can read between the lines. It's a probation sentence. It's not a serve 10 years in prison followed by, I know Mr. App wants to talk and he'll get to it in just a minute, leaning into that microphone. But I think we measure it in weeks. It's not months, but it's also not days. So if you were thinking, hey, next Tuesday, I'm back in New York, I don't think it's that fast. I think it might be a couple weeks. And so we just need to think through the logistics of this. It may make sense that I accept your plea, but I don't impose the sentence quite yet. And then you got to come back down here when you know you could block out the time you need to stay in Georgia, and you have a place where you are going to stay in Georgia. It's fine to have it be a hotel or motel, but if you got a friend or whatnot, it might be cheaper while you're down here. But you'll need to be here for a little while. So it may be that we don't actually finish everything today because you need a little time to line up. Hey, when could I spend a couple weeks in Georgia waiting for probation to transfer? Although, last thing, and then Mr. App can talk. Sometimes if you've got a fixed address in what we'll call the receiving state where you want to go, probation is able to say, you can be there while we work on that paperwork. It's not my call, it's their call. What do you want to add, Mr. Happ?
I was just going to say, we went through this process, Your Honor, on his prior conviction here. And I don't remember if Your Honor was the judge on it, but I maybe. And we had to get the probation transferred up to New York. And I think Mr. Charles would know better than, how long did it take when you did the last transfer?
It's about 4 days.
4 days.
Okay, so maybe it's faster. I just want to manage expectations. Maybe 4 days is great. But if it was 10 days, you got to wait till it happens. It's not that you say, I've waited long enough, I'm out of here.
And given the nature of the charges, it could take longer. The other, component, and I guess it's entirely up to probation, is and it varies from case to case, but sometimes they will, once he goes in for the first time, they'll give him like what I refer to as a travel permit, where they allow him to go back up to New York while the transfer is pending, as long as he's coming down here to report. And that tends to work the best, I think. But he understands that pleading guilty to this binds him to the state of Georgia until the probation is fully transferred up to New York. I've explained that to him, and hopefully probation is receptive to let him go back up and, go back to work and deal with family issues and everything else. He's got his life in New York while that paperwork and transfer is pending.
Tell me what
We can hope.
the family issues. Do you have a family member who's not well, or do you have little kids, or what?
I do have 3 daughters,
3 daughters. How old are your daughters?
15, 4, and 2.
So 2 very little ones.
Yes.
Do they stay with you?
Yes, they stay with me. I support them.
Okay.
Fully. I support them fully.
Who is with them now?
Their mother.
Okay, so you and their mother live together?
Yes, sir.
Okay, so there is an adult supervising them right now,
Yes, absolutely.
but you want to get back and help with that.
Yes. My employment in New York isn't, I don't travel from state to state. It's based in New York.
Okay, is it short haul trucking?
Yes. Yes.
Okay, and where in New York are you?
Long Island.
Okay, so family needs you back, work needs you back, but you understand that you may need to be here a little bit. I'm going to try to get someone from probation on the Zoom who could let you and Mr. App know, here are the steps you can take to streamline things, and we'll see. But Ms. Braswell just joined the call, so we're going to hear from her, and then we'll finish up talking about some of those logistics, and then I'll go through the rest of what I need to do, okay? All right, Ms. Braswell, good morning. I'm Judge McBurney, and I am going to add you to the screen here. I have heard from Mr. Abadi, who is the prosecutor who recently took over this case. Mr. Fawcett had the case for several years. He has left the Fulton County DA's office, and we pivoted to Mr. Abadi. He shared with me the facts and circumstances of your son's death as best he, Mr. Abadi, understands them, some of the strengths of the state's case and some of the weaknesses of the state's case, to help me understand why Mr. Abadi, why the district attorney's office, that's really what it is, why the district attorney has authorized a resolution that I understand is not something that you are satisfied with. It's important that you share with me how you're feeling, how this case has impacted you and your family. I recognize up front that it's been 9 years that you've been waiting for something, anything about this, because your son was shot and killed over 9 years ago, 9 years and about a month. So if there's anything you want to share with me, I would like to hear from you. You don't have to say anything at all if that's a difficult thing. Just having you here is making an important statement on behalf of your son, that he's not forgotten and that he's loved. But if you do want to speak, you can unmute and share with me what you want. Or you could send something to the victim advocate who's here in court and she could relay it. But you're on mute right now, so you'd have to unmute if there's something you want to share.
Okay, I'm ready.
Okay, so again, I appreciate you joining us. And the bit that you didn't get to hear, I guess the Zoom link hadn't made it all the way to you, was the state's presentation of their understanding of the evidence and some of the evidentiary challenges they would have if this went to trial. But more important, I'd like to hear from you about how you are doing and your thoughts about this situation.
Yes, sir. Thank you for allowing me to be on Zoom. Jeremy Dev has had a great impact on my life. Before he died, before that man murdered him, I was a Jehovah's Witness for 20 something years. I had a lovely life. I was happy. Now, after his death, I suffer from PSTD, post-traumatic stress syndrome. I'm very depressed. And I don't think it's fair that he even had the nerve to ask for probation when you've taken a life. He took my son's life. Okay, he could have broke his leg, broke his arm. No, he murdered someone. So the fact that he has the opportunity to see his kids when I can't see mine, he has the opportunity to be free while my son is laying in a box in my closet. I don't think it's fair. And I think if any one of those people in the court, if he had killed one of your children, you would know how I feel. He needs to pay. Even if it's a year or two, he needs to be in prison at least 5 years. I have forgiven this man, but he don't need to be free. He needs to suffer like I have suffered for 9 years. If he had killed your son or anybody's son in there, you wouldn't want him to have probation. My son is worth more than probation. You get probation for shoplifting, probation for DUI, for murder. Has Atlanta gotten that bad that you can kill someone and get away with murder? The DA, the judge, any of you guys, how dare you even insult my son's death by saying probation? And that's how I feel. It's ruined my life. I'm trying to get my life back together. It has ruined it, but to even offer him probation for a life, shame on you. And that's all I have to say.
Ms. Braswell, thank you for sharing your sentiments. I appreciate it. And again, I understand how difficult this is, that you've had to wait this long, and this is not the outcome that you would have expected, given what happened to your son. But it's important that you be heard, and you have been heard, and I'm glad that you had that opportunity. Thank you.
Please give him something. Give him a year of jail. Something. Something. How you gonna kill somebody and 9 years later want to get on probation? Where they do that at? Where? In Atlanta? No. Justice need to be, Jeremy deserves some kind of justice. This man should get 5, at least, I don't care, 2 years, 3 years. If it was up to me, he would get life because he took a life. That's how it's supposed to be. You take a life, you murder someone, they take your life. But this is not my decision. I don't want him to. I don't want him to get away with it. Please do something. If it's 2 years, get it. He needs to suffer. Please.
All right, Ms. Braswell, thank you.
Thank you.
I think it's important to reiterate, having heard from Ms. Braswell, the raw emotion of what she and her family has been going through over the last 9 years, what the state's review of the evidence led them to conclude, which is that this was a shooting in self-defense after Mr. Braswell had robbed Mr. Charles at gunpoint earlier in the same day. So we have a scenario that, as the state explained, there would be evidence that Mr. Braswell pointed a gun at Mr. Charles, took his property, and then later in the same day, the two encountered each other, and Mr. Braswell appeared to be reaching for something, and Mr. Charles, instead of waiting to have a gun pulled on him again, produced a gun and fired twice, not 10 times, but twice, and then fled the scene. I think the defense had the possibility of getting a justification verdict at trial where a jury would conclude that Mr. Charles was defending himself when he did what he did, which would be a not guilty verdict, and there would be a finding of zero responsibility on Mr. Charles's behalf. But instead, Mr. Charles is coming in here accepting responsibility for having taken Mr. Braswell's life. Mr. Charles going to prison for a while doesn't bring Mr. Braswell back. Mr. Charles going to prison for a while doesn't make it less of a potential self-defense case. And the last thing I'll observe is that it's the state that has the ability, and not the court or the defense, to downgrade the murder charge and the felony murder charge in the indictment to voluntary manslaughter. That is a power they use sparingly, and in my experience, only when the facts and circumstances justify that. And so it is not my role to second guess their decision to allow Mr. Charles to plead to a lesser included. It sounds like it's factually supported, and it's certainly legally authorized for the state to allow a defendant to plead to a lesser included. They've exercised that authority. It's now my turn to determine what a reasonable sentence is, given the facts and circumstances that have been shared with me. So, Mr. Charles, we're going to talk about the technical side in a minute. Ms. Simpson from probation has joined us, but I need to get down to the legal fundamentals that I need to cover with you. The first is that I find there's a factual basis for your plea. I don't know what a jury would do at trial. We've had an evidentiary hearing in this case where we heard a little bit about the photo identifications, but those were limited to people saying, yes, you stayed at the hotel, not that you shot someone, not that Mr. Braswell was acting in this capacity or that capacity. But it does sound like you were reacting to something as opposed to seeking vengeance. Nonetheless, a jury could find you guilty of voluntary manslaughter. That's when someone in the heat of passion takes actions that result in the death of another. And I think a jury could conclude that instead of there being absolute self-defense, which would require a verdict of not guilty, the jury could conclude that you were angry and so you pulled out the gun when you could have run. But of course, in Georgia, there's no duty to retreat. And Mr. App would have been arguing that very vigorously to the jury, that you didn't need to do anything other than protect yourself in that situation. And his argument would be that's what you did. And in Georgia, maybe the law of justification would cover that, but it might not. And a jury could have found you guilty of voluntary manslaughter, where in the heat of passion, as you're reliving what had happened to you just hours before when a gun was put in your face and your property was taken, you said, this isn't going to happen again. And you did what you did. So I think there's a basis for the plea. I also am very confident that your plea is knowing and voluntary. Knowing means you've understood what we talked about, and voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes, I do.
Okay. Then I'll accept your plea. Mr. Apt, do you authorize someone in my office to sign the indictment on your behalf and Mr. Charles's behalf?
Of course, yes, Your Honor.
Mr. Abadi, can someone in my office sign for you?
Yes, Your Honor.
So, Mr. Charles, I'm going to sentence you on count one. I'm curious, does count two merge into count one, or is it vacated? I heard you say you are reducing both to voluntary manslaughter.
It would vacate by operation of law. I meant to say that to Your Honor.
Okay, so count one, the state has reduced to voluntary manslaughter. Count two is vacated by operation of law. Felony murder, you're pleading guilty to count one, or you were found guilty of count one. Count two would be vacated. So count two is vacated by operation of law. Count one, I'm going to sentence you to 10 years to serve, well, I'm sentencing you to 20 years to serve 3 months. The next 9 years and 9 months are on probation. And then the following 10 years are suspended. You will get credit for the 98 days you've already served. So it's a total sentence of 20 years to serve. You're not going into custody. He's just getting someone back there. It's 20 years to serve 3 months. The next 9 years and 9 months are on probation. So that's the 10. And the final 10 years are suspended. I have found that it is not a good use of the limited supervisor resources in Georgia or any other state to have someone on probation for 20 years. Your sentence is 20 years long, and I'm going to set some conditions of your suspended sentence so that if you mess up, and I don't think you will, but if you get arrested for something next year, in 5 years, in 15 years, that suspended sentence I can still revoke. But it does mean that that period of supervision would be at most 9 years and 9 months. So at the 10-year mark, probation ends, but you still are under sentence. So it's a 20-year sentence. Just the first 10 are under supervision. The first 3 months were under the supervision of the sheriff of Fulton County. You've served those 3 months. You get credit for those 3 months. You actually did 8 days beyond that. Special condition of your probation is that upon your relocation to New York, you may not return to Georgia, with the exception of the Eastern Judicial Circuit. I don't know why you need to come back to Georgia, but I can't banish you from all of Georgia. So there's one judicial circuit you can go to. Otherwise, stay out of Georgia. Sounds like your work is limited to New York, and that lets you go elsewhere in the United States, but you don't need to come back to Georgia. That's where you've obtained your 2 convictions. You'll also need to have no contact with Mr. Braswell's family. Let them work through this process on their own. You've heard from Ms. Braswell how deeply she continues to grieve 9 years after the loss of her son. So she's going to heal in her own way, as will the rest of Mr. Braswell's family. It will be a special condition of your suspended sentence that you obey the laws of Georgia, the other 49 states, and the United States. I have to impose that because otherwise I couldn't revoke your suspended sentence if you do get into trouble while you are on this sentence. It's a natural condition of probation. So it's a similar sentence to what Mr. App negotiated on your behalf. It's arguably slightly less severe because those final 10 years, you're not on supervision. But I can always amend that if for some reason it seems like you need probation for the extra 10 years. But you'll be almost 50 years old by then. And I get the sense, given that you've had 0 arrests since this situation, that you are heading in a different direction and managing yourself in a way that's safer for you and safer for the people around you. And you just need to maintain that. And you will not have issues while you work through the rest of your sentence. Mr. Abadi, anything else on behalf of the state?
No, Your Honor, thank you.
Okay, before I get to you, Mr. App, Ms. Simpson, thank you for joining us on short notice. I'm gonna add you to the screen here. So Mr. Charles is a New York resident, and he has already once in his life had probation transferred to New York. He has a case slightly older than this one. The indictment is much older, but he lives in New York, works in New York, family is in New York. He's here now, and we just need to work through the logistics of how he can have supervision transferred to New York. We discussed a whole bunch of scenarios, but you weren't here for any of them. One was he returns because he's got a stable, secure address there and then comes back down here to deal with things. Another is because he was aware that he stays put here for a little bit, but he does need to get back to small kids, job, et cetera. And so I wanted you to share with him what he needs to do, the paperwork that you need to get so his lawyer can be working on that. And I know there's a small payment as well. So I'm going to hand the microphone over to you.
Good morning, Judge. That is correct. There is a $100 transfer fee that you must have in the form of a money order. They can, if you are able to remain here for about 45 days, that's the required time a lot that we have to ask. But it's up to the officer once you get over to the office to decide if you will be able to be permitted to leave before that. We just have to get the yes from New York. And it shouldn't be hard considering we've supervised and transferred your case up there once before. So I don't think it should be a problem, but we have to go through the process.
Okay.
So,
And I shared with him that you have to go through the process. It sounds like his best bet, Mr. Charles's best bet, is to just get over to probation ASAP to see what the time frame looks like. And then, Mr. Charles, you should let Mr. App know what they tell you, and Mr. App can reach out to me and the state if what you hear is it's going to be a particularly extended time. And then if I think it's appropriate, I can get in the mix to say I authorize Mr. Charles to be at his place of residence while we work through some of that. I can't overrule probation on all the pieces, but it may be that I can help enable you to be at home while waiting for that transfer to occur. But you can't start there. You have to start here, meet your officer, and get the process rolling. They may have questions they need you to answer face-to-face and not remotely. And then you'll get a better sense from that officer what the wait times are to get a transfer completed. Does that make sense?
Absolutely.
Can I ask just
Please.
a quick question? Ma'am, do you know, is it at least possible that probation would, while the paperwork is pending and the application to transfer it up to New York is pending, that he gets some type of like travel permit so he can go back home and then just come down here to report to probation until New York accepts?
It's possible that he can actually go ahead and leave. I can't make that call.
Right, I get it.
They have to make that call. So it is possible for him
Okay.
to be able to go ahead and head up there while
Okay.
the transfer is in process.
That's all.
I can say that. I just can't guarantee
Sure,
it.
but it's possible.
Right.
Yes.
Okay.
It's case-by-case situation. The nature of your charges may make it take longer. The fact that you've done this successfully before might make it take less time. And so you just need to let Mr. App know once your officer says, here's the plan. And if the plan is, look, it takes 3 days, don't ask to go back home, just sit tight. But if the person, you heard the outside window that Ms. Simpson said, 45 days, that's one where you're going to want to reach out to Mr. App saying, I can't swing 45 days in Georgia. Even though it's the World Cup, it's an exciting time to be here. And so we could see if there's a way to strike a balance between you staying plugged in with probation here and getting back home. All right?
So, Mr. Charles, let me give you the ICOTS officer's name and number. Let me know when you're ready.
Yes.
Her name is Officer Peaks. That's P as in Peter, E, K as in kite, S as in Sam. And the phone number is area code 678-331-9871.
Got it.
And
Thank you.
Sir Charles, are you still in Middle Island, New York?
Correct. Yes.
So the address that we had the first time we transfer you to New York, is that address still the same?
Yes, that's my home.
Okay. So we're good on the address side. They will go over everything else with you. So you're going to go to 276 Memorial Drive. That is our field office. And preferably, if you want, you can head there. Are you able to stay at least overnight?
Yes.
Okay. Preferably come in the morning, first thing in the morning, excuse me, because we need your signed sentence. And it's a lot easier for us to get it today and then for them to have it tomorrow versus you going over to the office and they can't do anything because they don't have your signed disposition yet.
All right. I'll get your final disposition. That's your sentence done this morning. And so they'll have that. So you're going to definitely need to sit tight today and then report to that address tomorrow. What's the earliest he can get there, Ms. Simpson?
Our office opens at 8 a.m.
Okay, so between 8 and 9, show up tomorrow. Your paperwork they'll then already have, and then you can start engaging with them about what's the process look like. All right?
Yes.
How'd you
Mr.
get?
I'm
Yes.
sorry. Can you please email me a copy of the police report?
Yeah, I can do that right now. Can you give me your email address?
Sure. It's ALYTIA dot SIMPSON.
SIMPSON?
Yes.
Got it.
At DCS.GA.gov.
Mr. App, I'll do it right now. I'll do it.
You got it? Mr.
Thank you.
Abate. Mr. Abate is emailing that over to you right now.
Oh, thank you, Mr. Body.
Of course.
So, Mr. Charles, you understand you need to stay here in Georgia until either probation or I give you the green light to go back to New York.
Yes.
And if probation tells you, it could be a few weeks, that's when you engage Mr. App. He'll reach out to me and I'll talk with the prosecution and with probation, and we'll see if there's a way to engineer it where you can go back. You may need to come back down here, but hopefully not. But you certainly need to stay here until either probation says, good, we know your address in New York, we'll keep you posted, or Mr. App tells you it's okay to go back to New York.
You had a question?
Yes, I have pre-trial conditions that involve the ankle monitor. I wanted to know that since this is coming to.
You still have an ankle monitor on?
He does.
Okay. Is it with Second Chance? Do you know?
Name of the company?
Yeah.
I don't, it's not with Second Chance. I could look it up on my phone, see what the name of the company is, but it's not, that doesn't ring a bell, so it's not with Second Chance.
Did you get your ankle monitor up in New York or did you get it down here?
Here,
Okay. Second Chance, are you paying for it or is the county paying for it?
paying for it.
You're paying for it. Okay, so I don't know who the vendor is. But you will be able to get that removed. This sentence that people are talking about, the final disposition, that's what you show to the ankle monitor company and they'll take it off.
Take it off when you show them the sentence.
Okay,
Your lawyer will get the sentence today because I will get it done. It will get put into the system and it will be emailed to him. And so he can get you a copy of the sentence. And so another thing you can do to fill your day today would be to go to whatever company is the ankle monitor company, show them that document and they'll take the ankle monitor off.
understood.
So you don't have pretrial conditions anymore. You just entered a plea. You now have probation conditions. And those are, once you relocate to New York, stay out of Georgia, except for the Eastern Judicial Circuit. But you can't leave Georgia until either probation gives you the green light or Mr. App says he's cleared it up.
I understand.
Got it?
Yes,
Any other questions?
no,
Okay. Reach out to your lawyer if something comes up.
yes.
Two minor points. I'm sorry, wasn't sure if the court was
Done.
two minor points I just want to put on the record. One is I understand he's banished except for the Eastern Judicial Circuit. If he has let's say he's flying from New York to Miami for see family or something.
Don't leave the airport.
Layover in Atlanta. I just want to make sure that that's not a
Right.
violation.
You stay at the airport.
And then the only other thing that I've had different courts treated differently in the last couple of years, and it has gotten messy with some sentences, but I do want to just sort of have it on the record that I don't know, or I don't know how this court will treat it. But I've had issues with the statute changed about 1.5 years ago, OCGA 42-8-37D, which now says that unless it's a sex-related case, if he hasn't had violations, then probation terminates after 3 years, even if he's not on first offender. And I don't know what, I've had some judges.
That is actually correct. He will come up for review at a 3-year point, as long as he has not had any violations.
Right. But it's come up for review. It is very possible to extend probation beyond 3 years. So it's the review that's at 3 years, which is appropriate. That is finally a statutory enactment that's consistent with why would you put someone on probation for 20 years? If you need to have the ability to have a real meaningful revocation, then suspend some of those years. As long as you include a special condition of obeying the law, you can do that. But it is not the highest and best use of probation's limited resources to be looking over someone's shoulders who is no trouble for 10 years. So I don't foresee an issue with that statute. Anything else? Okay.
Nothing else, Your Honor. Thank you very much for your time.
Okay. Mr. Charles, anything else?
No.
Okay. That's it.
Thank you, Your Honor. I am called in another county, so if this is all of my business, I'm going to ask to be excused.
Okay. I guess the shield didn't protect you.
It did not. I've
You
got
tried.
to pick a jury in Douglas County and spend the week there.
Okay. Enjoy it.
Huh. I will not, but thank you for the sentiment.
You bet. Ms. Percival, how are you? You may. I've got my notes and ready to go, but I don't see anyone here for that.
Correct, but if I can.
Yeah.
They emailed this morning, they still have not been able to get personal service on this journey.
Right.
I tried to email me again. Again, I got this just before I came up here this morning.
Okay.
She required personal service.
To do a 3-year one, my thought was we do a 30-day something.
And we've already done a little bit of that.
Yeah.
So we can extend it again a little bit. I'm not aware that you didn't, he's going to be things this were doing this.
Right. And then he's disappeared, and if they really cared, they'd hire someone who could find him and serve him. So my thought is, I'm happy to engage with them, but that's what I was going to propose. And frankly, I said, look, I'll just keep the case because the judge to whom it's assigned, not going to be here in 30 days necessarily. So why don't I hold on to it? And they would have it, you know what, in 30 days, we're going to reconvene. And if you haven't served them by then, I'm not going to extend it, but I'm happy to get back in the mix when you do. Yeah, let's do that. If he showed.
Correct. And he, last iteration was.
Okay.
So
Okay.
I will go grab them and bring them
Yeah.
up if that's what I would.
Yep.
Okay.
Great. Thanks for your patience.
Absolutely. Thank you.
Judge, thank you, have any excuse?
Yes, sir. Appreciate it.
Appreciate it.
Hello, Ms. Smith.
How are you?
I'm all right. Mr. Wright was on the call. He went away.
You sent an email that he was on the way because he wants to speak with his client.
Okay. He was on the Zoom real briefly, so maybe he wanted to let us know he was on his way. I haven't received an update about Ms. Williams. Okay.
I sent her a message.
Okay, if you could call her. I asked Ms. Nelson to try to track her down too. I don't want to keep Ms. Charles here unnecessarily if nothing is happening with the case. I'm assuming Ms. Charles is amidst that group?
Yes.
Yes, okay.
Yes.
Did you receive any communication back from Ms. Williams, or you just reached out? Okay. I know that she is having to cover for folks. You may have heard, their unit is down a bit, but this was on our radar.
Charles.
If she's informed, so you just want to come over.
Oh, that's fine. Thank you.
Oh, okay. There's another Anthony coming in. Well, what's that kid's name? Kanye Rowan. Oh, yeah. Scams. Got it. Judge Miss Williams is on the way coming from Judge Farmer's Court.
Thank you.
How are you? Good to see you.
Ms. Smith, will you be able to get these phone calls to Mr. Moran?
Yes.
Great.
Do you have those photos?
Good morning. We are waiting on a couple lawyers in another matter, so why don't we have a quick conversation? So I'm Judge McBurney, not Judge Whitaker. You guys can just come to the podium. Can you pronounce your last name?
Yes.
Mokatov. And is this Ms. Patel?
Yes.
All right, Mr. Mokatov and Ms. Patel. Ms. Percival's done a usual excellent job getting me up to speed. You represent Inglet and Stubbs, where Mr. Tarver worked.
Yes.
Past tense.
Yes.
I believe as a temporary worker.
That's right.
Very well documented, the threat of violence in particular at the head of security for the building where he was working.
Correct.
All sorts of legitimate reasons to be concerned for her safety and others in the workplace. We're up against some statutory bumps in that you want to obtain, I guess, the full 3-year or at least a longer, more permanent injunction.
Yes, sir.
But there's not evidence that Mr. Tarver's been served. So
Yeah, all we can do is, go to the places where he was identified. We had our process server do a skip trace.
he's not at the Myrtle address anymore, or they just haven't seen him there?
So he's well, let's put it this way. There were 2 separate apartments identified by the skip trace. We looked to serve both places. When that was unsuccessful, they went down to the leasing office, found a Miss Tarver. They went to her apartment. She was the aunt of him.
Of Mr. Tarver.
And
Okay.
said that he had left
Okay.
the apartment. He's on the lam.
Okay.
He has a probation violation in Tennessee as of 2023. Attached to my affidavit, he was convicted of aggravated assault
in 2021, along with,
What kind of background check did you guys do?
along
I
with.
mean, not you personally, but the firm.
Along with the possession of a handgun in violation of he was a felony convicted individual. So he had possession of a handgun as well. And so there are both historical reasons and current reasons to fear, not just Ms. Gassett, who was the head of security, as you said, but also Inglet and Stubbs when he sent, I'm going to kill everybody.
Right. No, this falls into these horrible patterns we see, unfortunately, on the news where someone comes back to the workplace and anyone who happens to be there is a target.
And that's why the statute was put in place in 2000 when there was a rash of those workplace violent issues in Atlanta. So I think we've done everything that we can to try and find this guy, short of hiring, somebody who can try and hunt him down. But apparently neither Tennessee, where he was convicted, nor Georgia, there is a warrant out for his arrest in Bartow County.
Okay. But the existence of a warrant doesn't mean anyone's actively looking for him. It means when he runs a stop sign, the officer gets the bonus, you didn't just run a stop sign, but you have to come with me because there are warrants for you out of state and in state.
Yes.
So that will likely be when Mr. Tarver has to deal with those two warrants. In the meantime, we need to do what's consistent with the law to bring some peace of mind to your client.
Yeah.
So I'm open to suggestions. It doesn't seem like it would be the full-throated 3-year injunction because Mr. Tarver hasn't had an opportunity to be heard, or it's the opportunity. And if he's been served, then we know he had the opportunity and he decided not to avail himself of it. And my sense is, from what you've shared and what I've read in the docket, is that he probably won't show up if he got the invite. But we don't know that he got the invite. So Ms. Percival and I were speaking informally about this, and a couple things I wanted to share with you. One, I'll probably just keep this case because Judge Whitaker's moving on to a higher position, well-deserved. We're excited for her, but rather than your client having to bounce around with judges, because I'm now about as familiar with it as Judge Whitaker was, I'll keep the case. You can transfer it to me. But work is a little more complicated than it normally would be. But I was open to the idea of another temporary something that says you got to stay away. I mean, he's not informed of it. So it's sort of like these TPOs that you get initially where boyfriend doesn't know he's supposed to stay away from girlfriend until he shows up. But then that's how you let them know you got to stay away. But it certainly would empower a criminal trespass call to the police if he were to show up. And then we'd need to see what happens over the course of the 30 days or however long we set that. I wouldn't want to be renewing it every 30 days, but it would sort of reach the point where your client needs to either invest in the
security.
Well, it's not so much that. I hope they do that anyway, but invest in the server, the PI who would actually find this guy, or we kind of have to call a halt to it until, I don't know how you'd learn, but if he is taken into custody and has to deal with Bartow or Tennessee, then we would know where he is and it would be easy to serve him. And if we needed to connect him with a civil hearing via Zoom from one of those facilities, we could certainly do that.
Yeah.
But that's the balance. Obviously, to me, the most important is the security for your client at that workplace and the individuals. But the statute does require, as would due process, Mr. Tarver's either participation or his knowing decision not to participate.
Right.
And we're in that space where I don't think you could show that he knows that he had a chance to be here today.
Yeah.
Does that seem fair? I'm not trying to be difficult.
It's not that it's unfair. It's unfortunate because we have twice now sent to his email, both the first time and the second time, the very same email that he used to threaten our clients. And while that is not service and he didn't acknowledge, right? In other words, we don't have any proof of life
but
Right.
yes, I mean, I understand it. It's explaining, and I think that's probably the best thing I can explain to my client is, look, you've done a lot already to protect your employee, including having us get this temporary injunction, but maybe you want to hire a PI and see what we can do. But this guy is wanted in 2 states, and so he might be doing a very good job of.
He might, but he's got to surface at some point. He needs to work, he needs to feed himself, et cetera. And PIs have ways of figuring out where is he most like, there's the girlfriend, there's the aunt or whatnot. So there's a reason why PIs stay in business.
Yes.
It's interesting. 3417D, which is what we're working on. This is how you got the temporary order. It says that it's in effect for a period not to exceed 15 days unless otherwise modified or terminated by the court. Not a lot of case law interpreting or applying this statute.
One case.
Yeah. And so my thought is one could modify it by extending it. And that's my proposal, is that we extend it for 30 days, 45 days, some window where then your client can make its own assessment of, are we going to invest in a greater level of pursuit of Mr. Tarver so we know he's served? Because that's all you need. I mean, it's not like the person has to Shanghai him.
That's
They
right.
just would need to say, here, the paperwork, and he can use uncouth language with the server, but you get that affidavit, and then we have the hearing you want to have. And it sounds like, from everything you've been able to put together, the much longer injunctive relief is put in place,
Yes.
which is what this intended.
Yes.
So that's my proposal. So it's not nothing, where there's some elasticity that seems appropriate given the seriousness of the situation. I think where a court might get wrapped on the knuckles would be if for a series of 36 months, so you'd get to the 3 years, there was a 1 month extension again and again and again where never Mr. Tarver was served. But that's not what I'm proposing. So tell me if that.
Yes, Your Honor, that sounds like the best thing that we can do in the near future to protect our clients.
Mm-hmm.
And also, it'll give my clients some time to consider what additional activities they want to engage in.
Right, and then we can reconvene, or it can just be email where you could say, you know what, we're not going to pursue this anymore, versus we'd like one more extension, and here's proof that we've taken additional steps, not gone back to the aunt's address again, but we brought in the tracker or whoever gets brought in to try to connect with Mr. Tarver.
Yes, Your Honor.
Would you get, please, to Ms. Percival, a proposed order that extends it 30, 45 days? You can pick the number and the basis for that in Word format. I'll make it my own, but it would be good to have something to build off of.
Yes, yes, Your
Okay.
Honor.
Ms. Percival, what are your plans? Are you staying here, or are you being elevated as well?
I believe that I am being elevated as well, Judge.
Okay.
But today, I'm available, and I can certainly email you what, a previous draft order.
Yeah, if you do that, and
I will discuss transfer provisions as well, Judge, just so that that's clear for the docket purposes.
yeah, if we just wait till like July 1 or 2, I don't know how that works with the family division, but
Oh, right.
that's why I said there's a little more of a hiccup. And I don't mean for it to go to Judge Ellerby.
Right,
It should,
I forgot about that.
Yeah.
But, congratulations.
hey, thanks. But if you would communicate with Ms. Percival, so get her that proposed order, you can get me the draft that was what led to Judge Whitaker's current, and then the new one. And then what I'll do is get my staff attorney into that communication loop, because if you email Ms. Percival a month from now, she'll say, well, it's not on appeal, so we don't have jurisdiction. So you want to use my staff attorney, but we'll loop you in with that person.
Sure.
Okay, anything
Thank you.
else?
No, that's it. Thank
All
you.
right.
Your Honor.
You're welcome.
Thank you, Judge.
You bet. Can I keep this?
Yes, Judge.
Okay. This will be my Inglet and Stubbs file.
It should be getting, e-filed, it should have been e-filed as well, it just isn't bringing up, obviously, it's Monday morning, you know.
Okay, yep,
Thank you, Judge.
you bet.
Judge, so are you able to keep certain cases?
So I would have to, ask to get the green light to hold on to something in particular. But if it is a case where I had a hearing on it, I have to resolve that. So anything that I tried, I have to do the motion for new trial. Let's say, take the Comer case.
I was thinking of.
Well, I had had the hearing on, so no, but I had had the hearing on your motion to sever. And so I would still need to rule on that. I did, but that's it. And then it becomes Judge Ellerby's case. So there shouldn't be, there's just on the criminal side, the Jackson Deno in the armed robbery case with Ms. Tembecca, but we'll get that order out this week. There's a bunch of civil stuff where I've had hearings, so I got to mess with that, but that's it. And then this. All right, we need to do Mr. Cunningham, but I don't see Mr. Wright yet. And then we need to sort out what, if anything, we're doing with Ms. Charles, but I don't see Ms. Williams, but she's coming from Judge Farmer. I guess she wasn't quite done yet because she'd be here by now if she was done with Judge Farmer. All right, then I'm gonna go back into chambers, and whoever gets here first, Wright or Williams, let me know. We'll come out and handle that. Thanks.
That's why people there.
Yeah. Oh, what did you say? He's like, what's he got on him?
Oh, yeah, some, covering the dance, and brown, something like that.
You're welcome.
That's why.
What? Oh, that, I remember reading
Yeah.
about that.
Yeah.
Oh my gosh. Little guy. Huh. 4. I remember when that happened.
That was earlier this year, right?
Yeah, January this year. Huh.
Yeah, I'm gonna take this,
Johnson down? Okay. I just did Mr. Charles's sentence, so I guess I'll go back till someone shows up. Miss Charlton, she's just hanging out with family.
Went to the drink machine.
Okay.
So she's not going far.
Are those all her kids? Some of them are her kids.
So she's got like, she takes care of like a niece and like the alleged victim is a niece and she's also got a nephew.
Got it.
So it's
It's family.
a mix, yes. Are you the intern that was talking about circuits outside of?
Yes.
Yes.
No.
Ben, Ms. Wood.
Yes.
Paulding County. So this, you guys were gonna meet at lunch on the 30th, but you can talk now. There's a little downtime.
Questions and all ears.
Did you, so Ben worked in your office last summer in the appellate section. So he's experienced the big office, Fulton.
Did you work in Paulding or Carroll?
No, he's worked nowhere small. He worked in Fulton County.
My office.
Yeah, I work with Lauren Shulo and Steve Scarborough.
Oh my gosh, okay.
Yeah, so he's experienced big. He worked, and so he came to court some, but he was tainted because he was Scarborough. But blessed to work with Shubo. But one of the things we've talked about is maybe being in a smaller office that's it's a different vibe. And so he was curious if I knew anyone who had done both. And I said, well, Lee Feely, it's a slightly smaller office, but DeKalb is still big. And then I remembered you. I couldn't remember if it was Carroll or Doug. I was like, somewhere that way. So anyway,
Great.
talk amongst yourselves.
Yeah, or I can over, or you wanna go to the jury room? I don't care.
Yeah, sure.
We need you, Lacey.
That, yes, please do, thank you.
Morning, Lacey.
Hi, Miss Simpson. Thank you. Thank you. Gordon, was that you this morning?
Yeah, that was me.
I did not know that was you. What was this young person talking to me? I don't know who this is. Nobody gave a quick away.
I know, I
And I just kept
figured
going.
you, yeah, I figured you didn't know it was me.
at this man.
I have my uniform on.
Okay, look at this Miami.
Yeah. Him outside his uniform, yeah, he get real brand new.
I was like, who is that? No, you're good. That's crazy though. Yeah. So, you go to the back room. Okay. So you come back out when you get here. Okay. To, boarding room. Okay. There's some calls too. No, I've never been farm before, so it's just a status kind of yeah, I mean, it's crazy. My eyesight is so bad. Where's Stacy? In the jury room, it's on to the anytime. It should come out. Oh, should I go back there? Yeah, you can. Yeah. Barwick after that. I have to go to Judge Barwick. No, we only have 3, but I picked up Judge Farmer because Katie is out on maternity leave. So will that be for the next couple of months? That will be, okay. Me and Dion are supposed to be sharing it. But with Dion out, yeah. Best wishes, warmest regards. The internet is out. I came to work. I was like, I'm gonna get everything done because I was not prepared for the sleep last night. I was like, I'm just get to work early. LOL. She's in the jury room talking to the intern. I made it. I'm so sorry. I just keep getting stuck in place.
That's okay. I mean, you're wearing many hats. Ms. Smith only has one hat.
For now.
Yeah, well, I know, it won't last.
For now.
Oh, no. I know, I'm so sad. Well, I guess I don't have to be sad anymore. I mean, it's coming. You can tell usually. Those that come in the door, you can tell. Actually, I'm just gonna come sit in y'all courtroom when Judge leaves. And the court. You have Ms. Wood coming?
Yeah.
I do have a question for her. Godfrey, you know Ms. Smith, how many cases does he have? Only three?
Three.
Okay,
Yes,
I wasn't saying. I just want to make sure I wasn't missing any.
Two are trial division, one is SAU.
Okay.
And I have a motion. I could feel that he was yes. Hello. I'm so sorry. That's okay. No, it's fine. Did you see what I sent you? Wasn't the offer three P's? Yes. I don't know if that makes a difference.
Okay.
I
don't.
See, coming out.
They
just went back and
Based on my.
So you got options?
Is Miss Nelson still in the room?
Yes.
No, she just walked out.
Okay, I'll give her a call. Thank you.
I mean, he does either, that's fine.
Yeah. We'll see what happens.
Is there any? So my question is it? Do you just really exercise your right to trial? Is that what you want?
Let me talk, and I'll come back.
Okay.
What are you up today?
I was being here.
Oh, yeah.
I was stopping here, but Your Honor, give me some more instructions. I do our ever evolving situation.
Oh, that's right. I know.
I'm just saying.
Okay.
I would have a great one.
Ever evolving.
I use my county phone with a hotspot, so that's why.
Yeah, I did use my hotspot because it's like super slow. Like even if you go to the booking profile.
Yes, so I'm using the county phone to eat up there. They don't, but when I use my phone, it's much faster.
But then they like,
Right.
they say they're working on it. I was definitely gonna go to the ball. I was just praying with this and that. They work.
It's just crazy, it's just like, oh my God.
And you said you have an emotion in that group today.
But I think it's been withdrawn. But I'm not sure. It's still scheduled.
What was it like a motion for?
Somebody else said it was sentence, like bond sentence. Okay. Keep that in mind. That everybody had this is what you were sentenced.
Right. So it needs to be modified. We got a revocation calendar, it's probably.
This one has, the defendant wants to be off the ankle monitor because head stalking case. Which is like,
Was he, so was the ankle monitor going seriously? Following his act?
I don't know, but all I'm saying is his ex off. You know what I mean? Like, right, no.
Yeah. Do you have Brandon Emmanuel?
Or,
You know what that is? That's verification. I just see the name on it. I don't know what the verification is. But I can go check, if it's technical, I can do it.
okay.
It's all right. See, nothing else. Yeah, there's a little more. It goes to failure to register whose case is this? I want to say yes or you, but I'm not sure.
And that's what so he picked up a new case.
Yes, so he committed a new offense of failure to register. He didn't do any community service hours. He didn't pay his supervising fees.
So, okay, so the new case, is it possible that we can hold off on that and do it as?
Man, see the court on the order.
That all makes sense.
It would be
Hello. It's always good to see you, but I got to tell you, seeing just you is getting more and more disappointing.
I understand you, I was in the neighborhood.
Okay. What's new?
I just asked where my client is, probably like, no response yet. As of Friday, they were wondering what we're doing.
Who's wondering?
Well, the client and her mother seem to be wondering.
Okay.
My response is, well, you need to be at Fulton County Jail.
Well, you got to turn yourself in here. They won't.
We need to come here.
Right. There's no, right. They won't take her into custody. Well, they probably would now, but it'd be easier for her if she comes here.
I'm trying to make that happen.
Okay. I know you are.
And there seems to be some confusion about the health issues and what that means. Based on what we were asked last week, there was a police system client's mother that were waiting on medical care before she had to respond. That was misunderstanding.
Yep.
So.
Okay. Well, I appreciate the update. I'm here every weekday. So if you know she's coming, give us a heads up. If it's like you get her and you like, look, I've locked the doors from the outside of my vehicle and we're rolling down here, just call.
Her mother's, she's in cheerful thing.
Okay. Whatever the production is, we'll be ready for it. Appreciate the update. Thanks for stopping by.
Sir.
Ms. Williams, good morning.
Good morning, Your Honor.
I was informed you were, as you forecast would be the case, covering things in other courtrooms. But we need to sort out if we're doing something today with Ms. Charles's case. Ms. Wood let me know that she had a counteroffer. This was just a chance for us to touch base to see, are we resolving? Because if we're not, it will go to the next available trial calendar, but with a different judge in the for what it's worth category.
Yes. I think this just needs to go to a trial calendar.
Okay, that's the plan?
Understood, yes, Judge.
Okay, so Ms. Charles, you will get notice of when you need to come back to court. Ms. Wood will tell you anyway, but something will be mailed to you. It's going to be 2 doors down. Another judge is taking over this criminal docket, Judge Ellerby. So it'll be 2 doors down, different person, same lawyer. So Ms. Wood will continue to be your lawyer. You want to stay in touch with her. Same prosecutor, I assume. That's the DA's purview as to where people stay assigned. But usually they follow the dockets when they move around. You guys will sort out whatever you're going to do. Okay? Appreciate it.
Thank you, Judge. Thank you, Your Honor. May we be excused?
Yes. Do we have any update on Mr. Wright?
Yeah, okay.
So I can let Judge Ellerby know, are things super far apart? They're closer? It's just, it's not happening.
I think that Ms. Wood and her client want to exercise their right to.
Okay. That's what we're all here for in the end.
Do you happen to know what our July trial date is?
Yes, if it's kept, and I think they are because the request was, and actually, Ms. Little, who is the litigation manager for Judge Ellerby, is now on the Zoom. So she can chime in if she's like, nope, we don't follow your dates. But I think the understanding was, please populate the calendars as you set them for a few months. And then Judge Ellerby is going to have her own cadence. It may be longer calendars, less frequently or more frequently. She works her own magic. But right now, there was a trial calendar call on August 6th for, it just says trial calendar call August 6th. So I checked with Ms. Nelson. I know she's working closely with Ms. Little to have that transition. We were just looking at, this is the trial calendar that was supposed to start today. I was being asked, should this go to August or September? So I think there is not a trial calendar for July. Having said that, it's not my July, and so things could change. And I know Judge Ellerby is going to want to have a meeting with the team anyway and talk about things. But I think it would be in August and, hey, Mr. Wright, and a September trial calendar, because the things we didn't reach here were, I was saying, well, that should go to August, Tavius, right? That should go to September, that kind of stuff. Okay,
Thank you.
you bet. Yes. What's your next stop?
Judge Barber.
Why is she still around? I don't even understand that. Is she retiring or not retiring?
That's what happens when you retire, you do whatever you want.
Yeah.
That's what we're gonna be saying about you, whenever you're.
Whenever.
Finally, see you.
So that's Mr. Wright. He's talking with Mr. Cunningham, and then we'll take care of, he's pleading to both cases, as far as you know? Okay. Has some driving issues. Was he on a trial calendar, or this is just a situation you guys worked out?
Situation we worked out.
This was the first calendar when it was published. It actually says courtroom 8B, Judge Ellerby. It made me sad. Yeah,
Not here.
exactly. Said, nope, June 22, still here.
Oh, I finalized my father's ticket that I actually.
Oh, yeah.
I got a John Deere S110.
Whoa, John Deere that's like going like with Porsche over, as opposed to Craftsman.
Yeah.
Yeah,
He was excited.
it's green too, so,
It is.
yeah.
Yellow. Yeah, it's pretty nice. So.
Would he already send you videos of him?
Yeah, I mean, it got dropped out, delivered, but he was at work, so I gave it to him on Father's Day. And
Yeah.
as soon as he saw it, it was like, I just put it on my phone and started recording. So I couldn't grab right in there. I'm like, oh, you could have made it. But-
That's funny. No, you can't wait. Fired it up. What does your dad do?
He's a machine operator
Where?
at, don't remember.
Okay, but in some,
He's in Villa.
okay, some kind of assembly something, and he's operating a big machine. So he would love having his own little machine now.
Yeah.
That's great.
That's a lot of money in 2 weeks.
You got some big space. You need to, maybe Father's Day, when Legend starts earning, he'll get you a ride-on mower. Or you could borrow, is it Mr. Smith? Mr. Smith's.
It's a little too far to drive.
Villarica? Yeah, that's a little, you could drive it. Mm.
We don't stay in Villa. He just works in Villa.
I
Down the street.
would have looked at something, they want someone to run right.
Oh, I remember.
Yeah, that's a serious,
Well, that's something about sit down.
like a riding mower. That's what she got. Yeah. She dropped some coin on Dad. Good.
You ain't me favorite. I'll tell you that.
Well,
That's how you solidify your spot in the wheel.
That's right. That is right. I will tell you, my kids were not vying to be number one on the wheel for this Father's Day. Nothing like that. 2 phone calls, and what did Roscoe get me? A new DOP kit for like when you travel. Like that's pretty much like getting you a tie. But it's very nice.
How old is Roscoe?
He's 15. He didn't get it, but he put his name on the bag that had it in it. He went to the gym with me, which I thought was nice. He's normally too embarrassed to do, like, Dad, you're just so embarrassing. You can't, no, I will not go.
About $2,000, ain't it? $2,000.
Very close to agree.
It's a good thing Father's Day is only once a year. You need to get a kind of big one because you know Legend will want to ride it with you. He'll be sitting in your lap. And so if you get this teeny one, he wouldn't fit.
He definitely would. Yesterday, we were outside, and we were like, hey, that's going out to the sun, but now it's too hot.
It's my kid.
So we came back outside around like 6. He likes throwing the ball. So I be throwing the ball on top of the roof and it
Rolls down.
He like doing that.
Does he catch it with a glove or just his hands?
Oh, his hands.
Yeah. So it's not a baseball thing. It's just,
Regular ball.
yeah.
I'm gonna have feet Thursday. Last Thursday.
Oh, yeah. How'd that go? Did it rain? I can't remember what the weather was like. Oh, right. That because I was supposed to go to the Braves game that night and it got postponed. So did you soggy afterwards?
I have a rain gear on.
Yeah.
We just stood on, I was on 10 turn at Bakery all day.
Oh, well, that's a busy spot.
Yeah.
Yeah. Huh.
By myself, just wishing I had somebody to talk to.
So there's a game Wednesday, but it's at night. It's at 6.
So Monday's, wait, this one?
Yeah, there's a game this Wednesday, 6 o'clock. Morocco,
At 6?
6 p.m.
Oh, you were.
I'm just telling you, that's the game there may be one though, but I just focus on the weekday ones. And this week there's a game Wednesday at 6 p.m. I think it's Morocco, Haiti.
Our next one is the 1st of July, next Wednesday.
If it's at 6, we could have pulled off drug court.
I know. I already fussed at Mr. Collins about that because they were asking, what about people who get sanctions? Where do you want them to come? I said, they should come to court. How do you turn yourself in on Fairburn Road? That's a big hoof. So you're right, 6 o'clock, we'll be done by noon. And there won't be issues down here. It's a ghost town on those days.
It really is, because I have not had any issues coming into court.
Yeah. We were driving to the gym yesterday and still on surface streets, and motorcycle patrol comes to this intersection where we had a green light. We were supposed to go, stops traffic. 2 more motorcycles go by with blue lights, and then 2 SUVs that have the World Cup logo on them go by, and then the motorcycle guy left. So I guess those are just muckety mucks. It's not a team. It was 2 SUVs on a bus. But yeah. Mr. Wright, are we good to go?
Almost, Judge, if I can have.
One last round of negotiations.
Yes.
Okay.
You were 2 for 1. It's 4. Yeah, if we can approach off record.
Okay, hold on one sec. Let me just get this out. All right, Ms. Toulos, we're not going to be on the record for this part of the conversation. Depending on how things go, I'll let you know if we need to be on the record.
Okay.
Mr. Cunningham, good morning. I'm all right. I'm Judge McBurney, and you've got two cases that are assigned to me. One of them, you weren't even going to have your first court date until July 7th, which you will still have if we don't resolve your cases today. That was for plea and arraignment. And the other one, I guess we already did the arraignment back in May, and I just don't remember. You may have waived arraignment, so we didn't meet. It may be that we were all together, but that was a little while ago. Either way, one case is moving a little faster than the other. They'll move together now.
It was non-complex, I think, Judge, and he got bumped up. So.
Well, it was listed as plea and arraignment with me on May 6th. And you did a waiver in April, and so it's possible that because you did the waiver, you asked if you and Mr. Cunningham could be excused.
And I think we waived the later in time case, and then the older case is probably what the July.
Yes, we met on that. Yeah, we met with.
Oh, okay.
Yeah.
Okay, well, either way, you will have a court date on July 7th so you got two cases. One of them is driving with a suspended license and you had a gun allegedly in the car. That is the lower number indictment, so it's the older case. It may not be older conduct, but it's the older case. That's the one that you had an arraignment with me in May. The newer case is the one that actually is tripping you up with the fleeing and attempting to elude. There must have been a kid in the car because there's a cruelty to children, and then all sorts of obstruction of officers, and again, driving with suspended license. So I'm viewing these as two driving cases. They'll move together from here on out, but the newer case needed to catch up. And you've got a court date on July 7th for that one, unless we want to just waive arraignment today since we're all together. That spare everyone needing to come back, but we'll talk about that in a sec. Mr. Cunningham, the bigger hurdle is this. Mr. Wright, I know, has been working hard on your behalf, negotiating with the prosecutor, Ms. Smith, and actually had asked that we get together today because you wanted to resolve both your cases. They don't sound like they're going to be particularly difficult cases for the state to prove. And so I'm sure your lawyer gave you good advice of, hey, you can fight this, but what's the thought of fighting it? It's probably on dash cam, this and that, who knows what, but the answer is your lawyer knows what. Today was going to be a day where you were going to plead to both, and I'd sentence you. You'd have the ability to withdraw your plea if the sentence I gave was more severe than what your lawyer asked for. But one of the things you're charged with has a 1-year mandatory minimum that I can't reduce statutorily. It's you do a year. And you've already done half a year because you got arrested in early January in connection with these. In fact, you were the 10th person to be booked into Fulton County Jail in 2026. That's how early in the year you were arrested. But because you have to do a full year, if you were to plead, there's a possibility that you could be sent to the Department of Corrections. And Mr. Wright has helped me understand why you've got some reasons to be nervous about that. Not because of the Department of Corrections, but people you might interact with there. And so your lawyer and the prosecutor and I were just talking about what to do. And I explained, I can't do much with that year. That year is there. Of course, every day you spend in custody is credit towards that year, even if you haven't pled yet. But at some point, if you don't go to trial, if you plead to this, the sentence is going to be at least a year. A judge can't go below that. And Mr. Wright pointed out, like, well, I think you're in Cobb County based on that outfit. Staying at Cobb may be a safer situation for Mr. Cunningham than going into the state system. I don't ever want to make that call for someone. You're the one who's been through it before, it sounds. But starting July 1, something changes. There's a different judge who will have your cases. I'm moving into a different part of what we do in court, and all my cases go to this other judge. And Mr. Wright can talk to you about whether that's a reason to try to work your cases out now or to respect your safety concern and say, I'd just soon wait things out until I've done enough time locally that I wouldn't get sent into the state system. I don't know that that other judge would necessarily wait that long. She might say, if it's not a plea, then it's a trial. And then, I'm making this up, but maybe it's a trial in September. And I don't know if you really want to go to trial or you'd still want to plead. Again, a conversation for you and Mr. Wright. But I wanted to make sure you knew everything that was going on, heard it from me, and also that you heard that you'll be switching judges as of July 1. So I'm here to do the pleas if that's what you want to do. But if for the reasons that Mr. Wright shared with me, you would prefer to have things move a little more slowly, then you will start seeing this other judge just a couple doors down and see where the case goes there. Do you have questions about anything I just shared with you? You may have things you want to talk about with Mr. Wright. That's great. We'll let you have a private conversation. But do you have questions for me about what's going on? No?
Judge, one other thing, and I appreciate the court's time, is there is a recidivist notice that if he pleads, the state withdraws it so that he can get non-recidivist. That means you don't have a mandatory serve on your sentence, notwithstanding the eluding. But one of the things that's at least good about this plea is with withdrawing the recidivist notice, he literally is only going to have to worry about that 1 year mandatory min that comes by statute.
Right.
Not because of recidivist.
Right.
So
that's a great point, because if
he understands, that's also part of the analysis.
Right, because if you go to trial, I suspect the state will not withdraw the recidivist notice. I suspect they'd ask for more than a year. And if you are found guilty at trial, if the judge sentences you to anything more than a year, that sentence is to the door. So I'll make it up, but if the judge were to say, I'm sentencing you to 5 years to serve 2, that would be a non-parolable 2 years. You do the full 2. But the state is willing to withdraw that recidivist notice if you enter your pleas today. And then you'd just be looking, I say just, it's still time, but you'd be looking at the year that you need to serve under the fleeing and eluding, which doesn't mean parole wouldn't look at your situation. I don't know what they do. They work in mysterious ways that I don't control. But you'd at least get out from underneath that recidivist notice. Apparently you've been in trouble before and the state has filed the necessary paperwork to empower the judge to give you a stricter sentence if you're found guilty at trial. Okay? You two want to talk a little bit more, or?
I was just going to go on the record. The state has said they'll keep the offer of today open. However, what judges, I think, explaining when it goes before a different judge, the judge always has to decide, is it acceptable to the judge? Whereas this judge may find it acceptable, maybe the judge Ellerby may not find it acceptable. No judge will speak for another judge, or just like as attorneys we can't. As long as you understand that we don't go for it today, the office will open and it's the same process of taking a plea and seeing what the judge accept the plea. But I wanted you to at least hear from the court, and I appreciate it, Judge, where our hands are sort of tied because the eluding is not going away. We have to deal with it, and there's only so much we can do. You see what I'm saying? So you can hear me, but also now you can see, okay, I'm hearing it from all the interested parties that our hands are sort of tied. All right? So saying that, Judge, could we just have a moment?
Yeah, talk for a couple more minutes. I need to know what you want to do. And if you want to sit tight, that's fine. No one's going to get upset. If you do want to work them out, I'm here to do that now. Otherwise, you should talk about the waiving arraignment as well. If the answer is, let's not resolve things today. If you do that waiver, then you and Mr. Cunningham won't need to come back on July 7th with the other judge. Okay.
It would just be for the one case to be arraigned, but now their cases are traveling together. You see what I'm saying? So if you resolve, you're resolving both. If you go to trial, it'll be one at a time, like one case. They're traveling together. That's probably why he went from non-complex with one to this division, and this division ended up with both cases. You see what I'm saying?
So you guys keep saying older case, so I want to make sure you know which one we're talking about. It's not going to change much because, as Mr. Wright pointed out, they'll move together after either July 7th or today, if you waive arraignment today. But let me get more specific because I can see the indictments now. So the case that you've already been arraigned on here, that you came to court in May, that's back from Thanksgiving of last year, November 23rd. So that's older in terms of the date of the incident. The case where you haven't had your arraignment yet is from New Year's Eve of last year. So one of them was November 23rd of last year, and that's where you had the gun in the car. The newer case, in terms of the event of the incident, was from New Year's, I don't know if it was Eve, day, what, it must have been late enough because you got booked in January 1. December 31st. Okay, well, the indictment says December 31st. I don't know if that's accurate or not, but that's what the indictment says. And that's the one with the fleeing and attempting to elude. That's the one that if you'd go to court on July 7th on, just to have your first appearance.
Judge, you can just have just a few minutes.
Sure. He left his kid in the car.
be.
Can you let them know, I need to know what's going on? Thanks.
You can't, but it's up to the judge. Yeah. Your Honor, respectfully, I think we're gonna ask to give him a little more time to chew on this.
Sure.
And on the 7th, since he's coming back.
So don't do a arraignment waiver now. Keep it on the 7th for arraignment.
Yes, Judge.
Sounds good. So Mr. Cunningham, you'll be brought back here, not here, 2 doors down, Judge Ellerby's courtroom on July 7th. Ms. Smith, the prosecutor, will still have the case, I think. And Mr. Wright, of course, will still be your lawyer. And you'll meet the new judge, and then your 2 cases will be flowing together at whatever pace Judge Ellerby moves cases, which is not a slow pace. Okay? Anything else, Mr. Wright?
Judge, I think that's it for today.
Okay. Ms. Smith, thanks for sticking around. Mr. Cunningham, you will meet Judge Ellerby in a couple weeks. See you guys around.
Okay, thank you, Judge.
You bet. Ms. Toulos, that is it. Thank you for your help today. And Ms. Simpson, thank you for jumping on with Mr. Charles. I've already signed the final disposition in that matter, so it ought to be available for DCS soon.
Thank you, Judge.
All right, you guys take care.